There we go.
Okay, looks like it's going.
All right, good morning, council. Welcome to the First District Court of Appeals. Happy New Year. First case that we have is State versus Baber. Ms. Nelson, would you like to reserve some time for rebuttal?
Minute, please.
I'm sorry, how long did you say?
3 minutes, please.
3 minutes. Okay, you may go ahead when you're ready.
Good morning, Your Honors, and good morning, Ms. Deere. Sarah Nelson on behalf of Town State Baber, and may it please the court. This case concerns several errors cumulatively affected the outcome and fundamental fairness of Mr. Baber's trial. These errors touched upon all phases of trial and included the ex parte communication between the judge and the jury, improper testimony by a state's witness, jury misconduct that was not adequately investigated by the trial court, improper judicial notice, and the improper non-disclosure of witnesses during the pretrial discovery. When we combine these errors with the fact that the state's evidence against Mr. Baber was not overwhelming, it becomes clear that Mr. Baber was deprived of his right to a fair trial, and a new trial is therefore warranted. Regarding the ex parte communication and improper witness testimony, the trial court acknowledged after sentencing that it did not advise counsel of a question sent out during jury deliberations. That question, can we zoom in on the surveillance video, involved a substantive matter because it relates directly back to the contested testimony of Detective McGuffey, who conveyed to the jury.
Well, it certainly does relate to a substantive matter, but I don't know what answer the trial court could have given other than the one that he gave.
He could have, well, with the consent and consulting with defense counsel, could have advised the jury again, testimony related to zooming in on the surveillance video has been disregarded. You've been instructed to disregard this. The testimony has been stricken. Defense counsel could have gone one step further and asked that they specifically relate to the muzzle flash, but at least reminding the jury, hey, if you're asking about zooming in on the video because there was testimony surrounding that, you were instructed to disregard that testimony.
What was the judge's answer?
No, the answer was no,
Okay.
Which is correct. They weren't allowed, they couldn't zoom in on the surveillance video, but you can't divorce the question from the testimony in this case, which is why affording defense counsel the opportunity to ask for another instruction, to double down on that instruction and remind the jury you were not supposed to consider anything surrounding zooming in on their surveillance video. It would remind the jury, hey, this muzzle flash testimony, because that's the harm here. Muzzle flash testimony, a fact that was not in evidence that the state's lead witness testified to, knowing that was, well, he seemed to equivocate. I'm not sure if this is a fact in evidence, and it wasn't. He shouldn't have gone that far and said, I was able to zoom in and see a muzzle flash. That's prejudicial.
Let me ask you about the muzzle flash, because obviously a gun was discharged. I mean, there's no dispute about that. So what does the muzzle flash add from a prejudicial standpoint?
So the muzzle flash connects the gun with the person the state perceives to be Mr. Baber. There are two issues here. Who was the shooter? Well, first, was Mr. Baber on the scene, which the state argues he was? And the second is, was he the shooter? And that's an interesting question because Jamal Killings admitted to being the shooter in the 911 call on the way to taking his son to the hospital. So that is a question that the jury has to grapple with. The reason why the muzzle flash testimony is prejudicial is because it connects the gun with Mr. Baber. Just before this, Detective McGuffey was talking about how he saw the Facebook photo with Mr. Baber wearing clothes similar to what he thought the shooter was wearing in the surveillance video, and saw a muzzle flash with that person, connects it to that person.
Ms. Nelson, let me ask you this. I know there was testimony over the course of the trial that based on the video and the physical evidence at the scene, I don't want to use the term impossible, it would have been very difficult for Mr. Killings to have fired the gun, in that there were bullet holes on the exterior of the automobile door in a position where he wasn't. Do you understand my question? I mean, there's physical evidence that says that Killings could not have fired those shots. So getting back to Judge Bergeron's question, what difference does it make if there was a muzzle flash or not? Additionally, having watched the video, something happened. People are gathered around the car. An individual runs up extends his arm as if to fire, runs off, but after, as he runs off, all the people that were there to assist seem to scatter as well. So at least in my mind, whomever that individual was, it was a shooter. Whether it was your client or not is a question. So I'm getting to my question, what difference does it make if there was testimony about a muzzle flash?
Well, we have to balance that testimony against the fact that Jamal Killings made the confession on the 911 call. So the jury is still free to disregard the, or to interpret the ballistics evidence, the firearm evidence differently in light of the fact that Mr. Killings made this confession. And in most instances, when people make statements like that right around the time of the event, the excited utterance doctrine comes to mind, because there's this inherent reliability that the things you say in the spur of the moment can be truthful. So the jury was certainly allowed to, view the surveillance video in a way where they believed that Jamal was actually the shooter. And not only that, but even if they thought that Jamal wasn't the shooter and the person with the arm extended, as you identified, the question is still, who is that person? So there's two issues here that the jury has to grapple with. So even if we get past the muzzle flash and this court thinks that that's not as prejudicial as we claim it to be, there is an additional piece of evidence here, who is the shooter, that was prejudicially asserted in this case with the Facebook photo. Another error that occurred at the trial court level was the fact that the judge took judicial notice of the date of this Facebook photo that depicts Mr. Baber as wearing similar clothing as that of the shooter. And why that's prejudicial is because the closer that photo is to the time of the event makes it more probable or more likely, more relevant that he was wearing the same clothing as that shooter. So it was not proper for the judge to take judicial notice of that date because it did not meet the standard for judicial notice. Facebook material is not reliable and capable of accurate, ready determination. And not only that, he didn't instruct the jury per Rule 201.
Well, I mean, look, I think that you're right that was error. I mean, we shouldn't be taking judicial notice of things on Facebook for a lot of reasons, but there was no objection to it. So, I mean, how do you get past the plain error hurdle?
Well, there was the clear legal rule here is the judicial notice rule, and the judge clearly didn't honor that rule. And the most important error in this case is the fact that he didn't advise the jury that they were free to disregard his judicially noticed fact as non-conclusive. So we have two errors now that speak directly to the ultimate issue in this case, which is the shooter's identity. We combine these errors again with the fact that there was judicial misconduct present in this case. A juror had disregarded the trial court's rule about not engaging in news media and shared that violation with the other jury members, to the extent that 9 jury members were exposed.
Did the juror, I don't remember if it was a he or she, but did that juror share that perspective with all the jurors, or was it just one juror?
It appears that 9 jurors were exposed to his statements, because what the trial court did was ask the jurors to cast a secret ballot identifying if they heard anything and who said it. And all of them unanimously identified the same person. And not specifically juror 13, but gave some characterization of juror 13. And when they were all brought in to talk about it individually, they reiterated that juror 13 was talking about watching news media. And during those individual sessions with the judge.
Well, but I want to clarify, talking about watching news media is one thing, but then coming in and expressing a view on guilt is another.
Yes, there is evidence in this record that jurors conveyed to the trial court that juror 13 had expressed an opinion about this case. And that's problematic. And why it's and that problem wasn't cured in this case because the trial court, went to the extra mile to bring in all the jurors individually, but missed a step by not asking each juror who was exposed to this communication, did it have any effect on your ability to remain fair and impartial? And while the trial court did try and correct that oversight by asking the jury in open court by a show of hands, was anybody affected by what they may or may not have heard? That is inadequate when we have 9 jury members who are potentially exposed to some degree of communication here, whether that was I don't know specifically how many were exposed to the opinion comments, admittedly, but they were all nine jury members were exposed to some degree of communication. And other jury members had mentioned the room becoming tense and people seemingly feeling uncomfortable by Juror 13's statements. And that is something that needs to be adequately investigated to ensure that this jury is fair and impartial moving forward.
The defense counsel didn't ask the trial judge to do that, right? I mean, they seem to acquiesce on how he handled things.
As it unfolded, yes, but it can't be ignored that this process and asking the jury about the effect of the communication had been discussed before each jury member was brought in individually. So that process had been laid out. It got missed. The defense counsel didn't aggressively ask for the effect to be further investigated, but it did nonetheless impact the fundamental fairness of this trial because we don't have an adequate determination here on this record whether the jury was able to be fair and impartial.
Well, let me ask you this, Ms. Nelson. It sounds like the jurors that reported the misconduct, and there's no question it was, were following the judge's instructions that if there's any misconduct, report it immediately to the court. And the jurors did do that. But additionally, in the final instructions, doesn't the court instruct the jurors that they have to decide this case for themselves? They have to decide it on the evidence before them and disregard any outside influences. So wouldn't that have cured it as well?
In a normal case, I would say yes, but we also have evidence that this jury disregarded the trial court's instruction to ignore stricken testimony. So I think that we have a problem with this jury and their ability to heed the trial court's warnings.
Well, as I said, I viewed that video myself, and I was compelled. I tried to zoom in on it, but my purpose was to see whether I could see the gun or whether I could see the purported shooter's face. So wouldn't we be speculating if we assume the jurors were trying to focus on a muzzle flash as opposed to something else?
Not in this case.
Okay.
No.
Okay.
I think the question to zoom in on the video would be more speculative as to what they were looking for if we didn't have the muzzle flash testimony. Respectfully, Judge, I don't think that we can separate the testimony from their request to zoom in this case. If we had one and not the other, then the prejudice would be more speculative, but we don't. We have both. They're independently prejudicial by themselves, but collectively, even more so.
Ms. Nelson, you are at your time if you want to reserve the balance for rebuttal.
Yes, Your Honor. Thank you.
Okay, thank you. Ms. Steer?
Good morning, Your Honors. Good morning, Ms. Nelson. May it please the court. I'll just start off with the muzzle flash, and I think as both Judge Bergeron and Judge Winkler indicated, even if, well, first of all, the witness's testimony, Detective McGuffey's testimony, the way that it came up was he was talking about how he knew that what the shooter was wearing because he said, I was able to stop and zoom in so closely on the picture. I was able to zoom in so much I could actually see the muzzle flash. And that's when the objection came because defense counsel, I think, believed that he was.
Well, but I think that is inherently problematic because you have a police officer basically saying, I understand what's going on in this video better than you, jury, because I have this special knowledge and you can't see that. So you have to rely on me.
Sure. And it was, and this was totally unsolicited by the prosecutor.
No, I understand that. I understand that.
The trial court gave the curative instruction saying that the jury was to disregard any of the discussion of a muzzle flash. And like the trial court said, after the defense counsel made their motion for mistrial, he said, reflecting what you've said today, that everyone knows there was a gun, someone was shot. There's really no mystery that there was a gun fired. The question was who fired the gun. And when you look at the video, around, I think it's probably 2 minutes and 41 seconds in, you see the man come running in And then you see as he's running away with his arm extended, shooting, and it's clear that the bullets went through, just like criminal.
Well, I mean, I've watched that video several times, and yes, he has his arm extended, but I mean, I looked as close as I could to see if there was any evidence of an actual shot fired, and I didn't see it. I mean, yes, his arm is extended as if he has a gun, but I think there's a difference between that and actually firing the shot. So I do think, you know, whether that individual is the shooter is certainly an open question.
I think if you couple it with the fact that with criminalist Phom's testimony, as far as which way the bullets came in, that they came in through the door. And in that video, it's clear that Mr. Killings was inside the door the whole time as he was unfortunately beating Jamie up. So it clearly the bullets came from outside the door and moved into the car, which matches up with the man running away with his arm sticking out as though he were holding a gun. And this is something that the jury was able to look at. As far as, if I could jump real quickly to the jury question, and yes, the judge should not have answered their question without consulting counsel, but like defense counsel said, the answer was correct. It was no. Whether or not the jury was trying to zoom in to see the shooter closer, which is what Mr. McGuffey said, he could see the shooter when he zoomed in, or whether or not they were trying to see muzzle flash, we don't know. And it's to speculate that they didn't follow the trial court's instruction is really going way beyond what we expect of our juries. We trust that our juries are going to follow instructions.
Let me ask you this. What did the state have any theory on motive here in terms of like, did Mr. Baber have any connection with any of the participants in this melee? I mean, why would he just come up and shoot someone randomly? I guess I don't understand that.
I don't think that there was nothing put forward during the trial about any motive.
And so the only way that they came to Baber in the first place was the detectives kind of Facebook scrolling and saw him in this outfit that looks similar to the outfit of the shooter. Is that fair?
I think what happened was police officer Gleckler, who was familiar with the neighborhood on Kendall, said when he heard the description of the shooter, he thought immediately of Baber. And it was because it was a young person. I think it was his height, maybe his weight.
I mean, but there were inconsistent descriptions from the 911 callers.
Sure, there were, but I'm just saying what detective or what officer Gleckler said as far as how he ended up going to Facebook. He said that he regularly followed the Facebook of the people who were in that neighborhood. And when he heard that it was a younger person, because most of the people on the street are older people, well, he said older as in 30-year-olds and up, but
That's young to me. So.
it kind of hurts me, but he just thought of Baber. And then when he pulled up the picture, he was wearing an orange and blue shirt. As far as there was no objection to the photograph being shown by the prosecutors, that photograph. What the question that came up was when the photograph was taken. During cross-examination, one of the defense counsel was questioning, I believe, police officer Gleckler, saying, you don't know when that photograph was taken. On redirect, the state wanted to try to show when the picture was taken by showing another Facebook page that had comments. And defense counsel objected to that. So the trial court said, well, we can say when it was posted. So that, to be clear, that's what the trial court said. The trial court said when the photo was posted to Facebook, not the date of the photograph. And so what was in question was the date of the photograph. He said it was posted on March 7th, and that's all he said. He didn't say what the date of the photograph was. Now, whether or not that's prejudicial.
Well, I mean, but do you agree that a court should not take judicial notice of, dates things are posted on Facebook? I mean, that just seems to open a Pandora's box.
Sure, it doesn't. But again, nobody objected to the way the court was going.
I understand.
Yes. I think that the court shouldn't have been taking judicial notice, and certainly the court did not instruct the jury how it was supposed to use the evidence that it had taken judicial notice of. But under a plain error review, there clearly is no outcome effect with this testimony. And if I could touch on the juror misconduct. So this alternate juror, I think it was alternate juror number 2, apparently had come in and started talking about having seen them on television, seeing the jurors on television. What he was talking about was news coverage of The View that the jury did. So this is early. He had seen, and I think maybe he had seen the bottom half of jurors and was speculating about whether or not he could pick out who he was. The judge, beginning on page 1382 of the transcript, the judge goes through and interviews each of the jurors. After they came up with this plan for how they were going to ask the jurors if they had heard anything, he goes through and he asks each of the jurors, did you hear anyone say anything? I think 9 of them do identify the alternate juror. None of those questions, I believe nobody there said he said anything about what he thought of the case. Most of them said that it was just him talking about what he saw on TV. They did say they were uncomfortable because they knew they weren't supposed to be watching TV. So it made them uncomfortable, I think, that the guy was talking about it. And it generally sounded like he kind of annoyed them all. So, I mean, whether or not...
If the judge is taking the extraordinary step of interviewing all of those jurors, why did he not ask the natural follow-up question, did this impact how you view the case?
That's a good question. Would have been a lot cleaner if he had,
Right.
But he didn't, and nobody asked him to. The assistant prosecutor actually suggested that after he finished talking to all the jurors and after they dismissed the alternate juror, defense counsel made a motion for a mistrial, and the assistant prosecutor said, Your Honor, I don't think that there's no effect on a fair trial here, but we could voir dire the jury and ask them if any of them were influenced by it. And that's when the court said, well, I'll bring them in here and ask them as a group whether or not they were influenced. Nobody asked them to do it individually, unfortunately. I'm sure had they done it, they could have gone through. But it just seems like when you read through the transcript, I don't think any of these jurors were going to be influenced. I think if anything, they were probably relieved to have this guy kicked off the jury because he was, I think, talking a lot and was a little distracting. Finally, I just want to touch on, just to cover the remaining assignments of error as far as the state's certificate of non-disclosure of the lay witnesses. The state did give reasons during the hearing. Detective Ballman talked about one of the witnesses being so afraid to come that she was...
Yeah, and I mean, Detective Ballman's testimony about that, with respect to one of the witnesses, I think, he gives specific instances why that witness was concerned. But for the rest of them, I mean, he paints with a pretty broad brush, like, well, these guys are known in the neighborhood and like,
Right.
There's concern, like nice passive description. So like, is that enough at the end of the day?
Well, interestingly, the person he was talking about was only 3 lay witnesses testified. Mr. Killings, Mr. Williams, who was the passenger in the car, and then Sharon Washington. The person that he was talking about was Sharon Washington. When you read his description of what she was afraid of and what she had seen as far as talking to her neighbor on the porch, and then she saw someone run by, when she gives her testimony, it's the same story. So that's clearly what Detective Ballman was talking about. And in fact, in the first trial, if you recall, there was a first trial that stopped before the trial actually started. It stopped during voir dire. And during that trial, I think it's on page 520 of the transcript, they actually had to issue a subpoena because she wasn't going to come in. So this was the woman that was scared. That's the witness who was talking.
Well, but then if there's only 3 witnesses out of the 10, it was 10 that were non-disclosed.
I think right? 8 or 10. Okay.
And I mean, well, what does that say about the balance of them, and should those have been on the non-disclosure list? They were like the other 911 callers, right? Who clearly didn't have evidence that was helpful to the state. So like, why would they have been presumptive witnesses?
I'm not sure why they were on the witness list at first. I'm sure the 911 callers were. I think Detective Ballman said that they just decided that they weren't reliable, so they didn't use them. I think once Detective Ballman said that, I know he did lump them all together, and maybe he didn't specifically say each one's statement as far as being afraid, but he did say that all of them were expressing the same concerns that Ms. Washington had expressed.
The 911 callers that provided the exculpatory information were scared?
I don't know if he said everyone who was on the list. Unfortunately, we don't know who was all on the list. I guess I could have gone back in the first voir dire and seen when the state read off the names of the witnesses to see if those were the 911 callers.
But clearly the ones that are not implicating Baber wouldn't be scared that Baber would come after them, right?
I would assume so.
Right.
Right. All I know is what Detective Ballman had testified to as far as them being afraid. And even if the trial court abused its discretion in allowing the state not to disclose that, as I argue in my brief, there was no prejudice here. Only 3 of them were called. They had the information. I think voir dire stopped on a Wednesday. The state turned over the list on Thursday, and then testimony didn't start back up again until Monday. So they had plenty of time. And the
defense had time to call in the exculpatory witnesses if they wanted to do that.
Well, all I know is they didn't ask for continuance for more time.
Okay.
I think it would be a different story if maybe they had expressed that they needed more time and the court denied that, or if they had asked for it. And in fact, they did have at least the redacted statements, because I think one of the defense counsel said, we've gotten this. She complimented the state, saying the state's been really good. Thank you for the redacted statements. So I think, they at least had that part of it. And I don't know as far as what they had as far as the 911 calls. It's possible that they had the 911 calls without the identifying information of those as well.
Ms. Steers, did the defense play those 911 calls? My understanding was that there were differing descriptions, like a white hoodie, a green hoodie, a blue hoodie. Did the defense play those 911 calls for the jury?
Yes, they did. They did. Right at the close of their case, they played them there, and then they mentioned them during their closing argument.
Okay.
And I'm sure, as far as the final assignment of error with respect to the violent offender registry, this court has already decided that issue in Reich, and the Supreme Court, I think, is having an argument on it in April. So I think that one is probably not well taken. So unless you have any other questions, the state just asks that you affirm the conviction.
Okay, thank you. Thank you. Ms. Nelson, you have 3 minutes. And maybe you could start with the prejudice point on the non-disclosure that Ms. Steer was referencing. Like, you get the name. Maybe if we assume that the detective's testimony was inadequate, and you should have had that earlier, like, what is the prejudice?
So again, this is an identity case with eyewitnesses. We know very well that the longer we wait to interview and investigate eyewitnesses, the more likely that the memory of the event is going to fade or defer. We need to investigate and talk to those witnesses as close as possible to the event. As soon as the state realized that witnesses subject to the non-disclosure were not going to be reliable witnesses for them because perhaps they identified somebody other than their suspect, those names needed to be disclosed to defense counsel. That's the harm in this case. There were eyewitnesses that were not disclosed, and it seems because it was more convenient for the state to not turn them over. There was no articulable reason for these witnesses to be withheld.
What I'm kind of confused on, and maybe you can help me if this is in the record, was defense counsel, they weren't provided with the names of the exculpatory 911 callers, but were they provided with the 911 calls or the redacted statements early? So they knew there was this exculpatory information?
I think you're referring to the first trial setting where the names were announced.
Well, I'm just wondering if defense counsel, even though they didn't know who, like the actual 911 callers that they could actually go interview, did they know that this evidence at least existed, that people called in identifying somebody else as the shooter?
It's my understanding from the second trial setting that they had redacted what I thought was the redacted 911 calls. They didn't have the names. So they weren't able to connect names with that were announced in the first trial setting to the 911 calls, assuming that they got the redacted statement somewhere along the line. For sure, we know that one 911 caller was on that list of names that were disclosed in the first trial setting, but we don't get to figure out the opportunity to investigate the person because we can't connect them to the 911 calls until those names and addresses and things like that are disclosed at the second jury trial setting. So,
but there
no.
was the defense never asked for a continuance to investigate either, right? So they finally get the names and the contact information, and they don't even ask for time to investigate.
No, they worked the 4 days, the weekends that they had before the review. So work with what they were received.
And we don't know from the record if they actually did complete an investigation or anything, right? I mean, I guess that goes to the question of prejudice. It's kind of hard to tell from the record.
I think, well, again, even if it's not prejudicial in and of itself, it does speak to a larger issue in this case, the cumulative error of all of these prejudicial errors. So at the very outset, defense counsel was not able to investigate eyewitnesses, and it can't be overstated how important eyewitnesses are in an identification case, especially ones that have an alternative interpretation of what happened, who was the shooter. So that in and of itself, I know defense counsel didn't ask for any continuance and didn't do things that would sort of trigger more prejudicial, alarm bells at the time of the trial, but when you consider it in the totality of the circumstances of this case, the combined prejudice absolutely impacted the fairness of this trial and defense counsel's ability to adequately investigate these potential alternative witnesses. And at the time, they did play the 911 calls, they did get that evidence to the jury, but that's a lot different than having a live witness say, this is what I saw on the day of the event, and being able to investigate that thoroughly at the outset.
And Ms. Nelson, you are at your time.
Thank you, Your Honors. We just ask that you would reverse and remand for a new trial.
Thank you both. We appreciate the arguments. The case will be submitted and we will get out a timely written decision.
Thank you.
Morning, Council. Happy New Year. Welcome to the First District. We're now here ready to hear State versus Muhammad El. Mr. Hoffman, would you like to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 3 minutes.
Okay.
Can the court hear me all right?
Yes, yes.
Very good.
You may proceed when you're ready.
All right, thank you. I represent the appellant, and this is an appeal from an assault conviction, and it was a plea of no contest that was entered after a motion to dismiss was denied. And the motion to dismiss was based upon post-accusation delay in serving a warrant to arrest on the complaint. This was a misdemeanor 1 assault. And the unusual aspect of this case is that the hearing on the motion was a joint hearing that involved a second complaint for aggravated menacing. And the motion that was filed in this case, the motion to dismiss the complaint for assault, only mentioned the assault case. It didn't mention the aggravated menacing case. That case was filed almost a year after the assault case was filed, and it was filed by a different officer. But again, the hearing proceeded on both complaints. And both officers eventually testified to their respective efforts at serving the warrants on their complaints. And at the conclusion of the hearing, the trial court, as I said, denied the motion. The complaint for assault was filed by Officer Staples of the Cincinnati Police Department, and the aggravated menacing complaint was filed by Officer Kress. And they worked independently. Officer Kress did not testify to any efforts he made to serve the assault complaint. And Officer Staples only testified to what he did to try to have that warrant on complaint served with respect to the assault. And so there wasn't any intermingling of effort with respect to the two complaints, the service of the warrants, I mean.
Well, right. I mean, it sounds like it was probably not the most strenuous effort to locate this individual, but I mean, he was by all accounts homeless. So I mean, what do we expect from the state in those circumstances?
Well, the trial court did base its decision on the fact that there was no address, but specifically the Pamela Martin, the victim in the assault case who testified at the motion hearing, after direct and cross-examination of her, it became pretty clear that she just didn't know his address. It wasn't so much that he was homeless. The database referred to by Officer Staples indicated there was no address, that he was homeless, as far as the police were concerned. But Ms. Martin didn't really establish that he was a typical homeless person. And even if
was there information presented that he did have an address and it was obvious and the police just didn't go there?
No, that was not presented. The police did not have an address to use to find him.
I know they didn't have an address, but was there an obvious address that he had? I mean, I guess it's just kind of, you're arguing against the fact that he was homeless, that maybe he did have a place that he lived that they could have found easily. Is that your argument?
Well, many homeless people do have places that indoors. They could have hotel rooms or flop houses, charities. They can stay with relatives. They can stay with friends for up to 6 months. They could be considered homeless, even though they have an address. And sometimes, a place to stay. And sometimes the homeless people do have an address where they receive mail, but that isn't where they stay. If this were a summons, where and a mailing address would be used, that would be different. But I think the critical idea is where he was staying as opposed to a mailing address.
Well, I mean, but aren't the cases where we really fault the police for not serving a warrant is when there's some sort of evidence that the defendant was staying in a location and that was kind of a place where he always was, and they were just negligent and failing to find that? I mean, isn't that when we really fault the police?
In the case of a warrant on complaint, yeah, an arrest warrant, the key issue is to find the person where they're staying. It could involve that they could have checked social media. The habits of people could be employed or looked into to try to find people. Knowing the area, knowledge of the area where the district is can help.
So you're just faulting them for not doing that stuff, but you're not saying that if they had done the stuff, it would have been fruitful.
Well, I don't know if on an appeal I could argue, what hypothetically, what would have happened if efforts had been made.
Well, you could have presented, or there could have been evidence presented that he always stays at this particular location, and it would have been very easy to figure that out if they had done some minimal investigation. But that's not in the record.
Well, right. Like if he had a Facebook post and said, "This is my address, this is where I'm staying," like that would be a pretty powerful piece of evidence to show that the state had dropped the ball and hadn't been diligent.
That's true. Now, the efforts of the police, though, have two roles in this Barker analysis. I think that the lack of effort, irrespective of the lack of an address, would warrant a findable negligence with respect to the reason for the delay.
And I think we would agree with you that there was a lack of effort.
But the important critical part is the presumption of prejudice. Presumed prejudice is part of the mix under Doggett versus U.S. in every case like this, and I think that the fact that this is a 2-year delay, which is right at the edge of the statute of limitations for a misdemeanor, and if you just isolate the efforts, the lack of effort of Officer Staples, I think it would permit the court to presume prejudice, even though the defendant didn't testify and say that he had an address at a certain place or that he was staying at a certain place.
What about, there was evidence in the record that he failed to report to his probation officer about 2 weeks after the assault. And so, you know, that the fact that he just didn't show up, I mean, he was on probation and didn't show up. I mean, is that a factor that we can consider, right?
Yes, I think that actually cuts in my favor, because being on probation is one of the things that the officers could check to find the person. And also, the police, people that serve process to homeless people run their names not just as defendants but also as victims, because a lot of times homeless people can be victims, and so that's another thing that could have been done that wasn't done that might have aided the search for Mr. Mohamedel.
So
Mr.
you're
Hoffman,
asking us, I'm sorry, go ahead. Go ahead, Judge.
sorry, Mr. Hoffman, had he reported to probation 2 weeks after the incident, he would have been arrested on the warrant, though, correct? Or at least advised of the warrant? I mean, couldn't that cut the other way too? Is that he was aware that there was a warrant for him and he decided, you know what, I'm going to stop reporting to probation because I expect I'll probably be arrested at that time.
Well, I guess that would assume that he knew that he was charged with the offense. I don't think there was any evidence in the record that he knew that this assault charge was pending. I don't think there was any evidence that he fled the scene. He just wasn't present when the police arrived.
Let me ask you this, Mr. Hoffman. There's during the bond hearing, counsel attempted to get a bond set on the probation violation. Then Ms. Martin was there as well, and she said that I think she used the term is elusive or is good at eluding. Should we consider that at all in our analysis?
Well, I did refer to the bond hearing with regard to his employment. That did take place prior to the hearing on the motion to dismiss.
Yeah, it did.
It wasn't a part of the hearing formally, though. But like I said, I referred to it as well. I guess that's something that the court could consider as a part of the mix.
So your prejudice argument is that we should presume prejudice? Is that your argument?
Sorry, Your Honor.
You're asking us to presume prejudice in this case?
I think that under Doggett, I can, because in Doggett, the district court and the Court of Appeals didn't consider presumed prejudice, and the U.S. Supreme Court analyzed it and said that it's a mistake to disregard it. So, and it used language that said that it was a part of the mix and properly in any Barker analysis. So yes, I would ask the court to engage in that analysis, but when you do it, I would ask that you isolate again. I don't mean to beat a dead horse, but Officer Staples didn't look for him at all. All he did was refer this thing to an investigator. And I think that's similar under State versus Jackson. This court held that that's like putting something into a database and doing nothing else. And I think that's findable negligence. And I think it also is important in the prejudice analysis, the analysis for presumed prejudice. Let's see. The other factors I think weigh in my favor. That the period of delay was 2 years. This motion to dismiss was filed 8 days after Mr. Mohammedel's arrest, and also there was particularized trial prejudice in this case, which is, you don't see that every day. The state's discovery response, which was filed prior to the hearing, indicated that this body camera footage was outside the retention period, which tends to indicate that there was body cam footage that no longer existed at the time of the arrest. And so the delay did hamper the defense's ability to prepare a case, I would argue. The other particular...
We know for sure there was body cam video that was deleted.
Well, they check a box. There's 4 different scenarios in this response. One that is that it has been forwarded, and then the other one forwarded upon receipt, and then it says, I hope I'm not yelling into the computer, video beyond retention period, and then no video. And they didn't check the no video. They said the video's beyond the retention period, which I think indicates that there was video, but not anymore. And so
Hoffman, you're at your time if you want to reserve 3 minutes for rebuttal.
all right, thank you, Your Honor. I would respectfully ask that the court would reverse.
Thank you. Ms. Whittle?
Morning, Your Honors, and may it please the court. Megan Whittle on behalf of the City of Cincinnati. In this case, the trial court did not err in denying the defendant's motion to dismiss. There was no particularized prejudice that was elicited in this case, and so that weighs against defendant.
Well, I think you've basically conceded 3 of the 4 factors. So like, why isn't that enough to tip the scales in favor of the defendant here?
Well, if you look at this court's decision in Rogers, the first 3 were essentially weighed negligibly in the defendant's favor, and it really just came down to that last prong of whether or not there was particularized prejudice. So in this case, in terms of the length of the delay, 24 months, like I say in the brief, would necessitate review of the Barker factors. The reason for the delay, I would argue, is negligible at best toward defendant. By all that we have in the record, he did not have an address. He did not have a phone number. That was in 2017. In 2018, his address in RC.
What about the probation overlay here? I mean, wouldn't they know where he was to be located?
Maybe. I mean, I think that if he had an address, I don't know if probation knew that.
Well, is there any evidence that the officers reached out to his probation contact?
No, there's no evidence of that in the record, and it wasn't asked of by defense counsel on cross either. So we don't have that in the record to say we coordinated with probation to try to find him. But he did fail to report to probation 2 weeks after the assault happened in 2017. I know that it's not in the record that he was attempting to evade the police, but I think if he failed to report to probation 2 weeks after this and then was not able to be located until he was picked up on these 2 warrants, that also goes to show that he was not readily available.
How about the loss of body cam video? How is that not prejudicial to the defendant?
So the body cam retention would be 90 days. And so really any delay past 90 days would then be prejudicial if cases weren't brought within that time period. I think it's important to know that Pamela Martin, the prosecuting witness on the assault trial, was still available. She was there. She was able to testify at the bond hearing. She testified at the motion to dismiss hearing, and she would have been available for trial. So she certainly could have a firsthand account of what happened. Importantly, Mr. Mohamedel was not on scene when police arrived, so there wouldn't be any of his statements that could have been lost.
Yeah,
So
but there could have been statements by the victim that were contradictory to what she eventually would testify about, right? I mean,
potentially. I think we just don't know. We don't know what would be on there.
Well, but I guess that's where I'm struggling from a prejudice standpoint. we don't know what we don't know, but I mean, how is the defendant supposed to make out a prejudice case when evidence in the state's possession has been destroyed?
I'm sorry, my
I say,
internet.
how is the defendant supposed to make out a prejudice claim when evidence in the state's possession has been destroyed?
So I think that importantly, in what was before the trial court in this case, there was no evidence that was placed before the court as it related to this specific motion about body cam. So I think if we look at our discovery response, it does indicate that body cam is beyond retention. But what was heard before the trial court was nothing related to that. Counsel did not bring up the discovery response and say, Judge, they've said that the body cam is deleted. She didn't ask the officers, did you have body cam on? It was just her argument that body cam had been deleted. So there was no actual evidence placed on the record during this hearing that it existed or was deleted.
So in other words, like if the question had been asked of the officers, like, well, what would the body cam have shown? And the officer said, well, we interviewed the victim afterwards. Then like that, according to your theory, like that might move the needle more towards prejudice.
Potentially, but I think that also cuts in the defendant's favor, because if the state is not able to, or if the victim, is, I guess what I'm trying to say is, in the case of when evidence doesn't exist, sometimes that also works in the defendant's favor in terms of, hey, the state doesn't have this, so how do we know? The state, wasn't able to produce this thing that we had, and so you shouldn't trust our investigation. So I don't necessarily think that the lack of it automatically means prejudice to the defendant. So I would say that in this case, Your Honor, if there were testimony put on, hey, what did you do after you responded to the scene? Was your body camera on? How long would it have been on? It would be a different analysis. But what we have in this case is just the argument by counsel that it had been deleted, not what potentially would have been on it, or anything along those lines. So I don't think that there was an adequate showing of actual prejudice in this case. And so if we move to presumptive prejudice, like Mr. Hoffman argues, 2 years is longer than most of this court's decisions in which it's found no presumption of prejudice. But the distinction between this case and those cases is that we don't have an address. We don't have a phone number, at least what is in the record here. If you look at Sears, there were no attempts, but there was they had an address. They just didn't go find it. If you look at Rice, that was an 18 months delay. The state was dilatory in bringing him to trial. They had an address, but they also knew he was incarcerated, where he was incarcerated, and they did nothing. And then if you look at Jackson, that's 4 years. And the officers did things in that they had an address, several addresses that they checked, but that was really the length of the delay. So if we look at the facts here, yes, it is a 24-month delay, but we don't have an address. We do not have phone numbers. When we check RCIC, it says 100 no home. And the officer indicated that he knew from 2 prosecuting witnesses that the defendant frequented Price Hill. So he went out and looked for him in Price Hill. But I mean, you can't knock on every door in Price Hill looking for someone who doesn't have an address. So I don't think that there's a presumption of prejudice here, because these cases are distinguishable. And that 24 months is nowhere near the 4 years that we saw in Jackson. And if we look at Bush from 21 and a half months, non-supportive dependence case, this court said we should not presume prejudice. So I would ask that this court find that there is no presumption of prejudice, that there was no demonstration in the hearing, in the record, of actual prejudice, and that it affirm the decision of the trial court to deny the motion to dismiss. If there are no further questions, then I rest on the merits of my brief and ask this court to affirm.
Great, thank you. Mr. Hoffman.
Yes, Your Honor. The traditional test under Barker looks to the efforts of the officer and not the difficulty in so much in finding the defendant. If you have periodic and regular efforts to serve a warrant, that usually saves the day. And in the cases cited by my opponent, you did have that. In Bush, you had efforts like that. Rogers, you had 3 attempts to serve the warrant, and same within Jackson. But in this case, again, I mentioned, if you just look at the efforts to serve this warrant, the warrant for arrest for assault, you have no efforts. You don't have periodic and regular efforts to serve the warrant. You have no efforts. You have a referral of that warrant, which is the warrant we're concerned with here, to an investigator, and that's it. That's why the concession of the first 3 points of this test is going to carry. I think there's nothing to compensate for it. I think you don't have the efforts you need to not find prejudice in this case. I think presumed prejudice has to be found because of the lack of effort of Officer Staples, and the efforts of Officer Kress shouldn't relate, because that was a different warrant. He was trying to serve a different warrant, not this warrant. And so because of that, I'd ask that this court would reverse and find that my client's Sixth Amendment right to speedy trial was violated in this case. Thank you.
Thank you both for your arguments. We appreciate it. The case is submitted and we'll issue a timely written decision.
Thank you, Your Honor.
Have a good day.
Not this one. And so
Great. We're moving on to the next.
Yeah.
Okay.
Good morning, Your Honors.
Morning.
Morning, Your Honors. We have audio.
Mr. Stolf, we could hear you, but I don't have the video yet. Oh, there you are.
There he is.
Good morning to you both. Happy New Year. Mr. Stolf, would you like to reserve any time for rebuttal?
5 minutes, Your Honor.
5 minutes, very well. And you may proceed when you're ready.
Thank you very much. May it please the court, Dale Stolf here today representing the plaintiff appellants Cornell and B. First of all, I wanted to thank the court for setting this on a regular calendar. We needed every square inch of our brief up the page limit, and we appreciate that. One thing I will say is, our brief, we took great pains. There's a voluminous record here. We took great pains on our brief to cite to the record, to the docket, to the transcript of proceedings and all that, as required by the local rules. Mr. Shane did not do that. He attached extraneous matters to his brief and really took a lot of liberties, which I think we pointed out in our reply brief. So, I'm glad we've got 2 former trial judges on the court here today. And of course, I know Judge Bergeron has extensive appellate experience and will appreciate the fact that, one of the things the trial court needs to do, it's vested with a lot of discretion, but it's got to follow the rules. It's got to follow the procedures. And I know everybody on this panel appreciates that.
Well, so maybe let's start at the basics. I mean, you agree that your clients did not satisfy the monetary requirement of that order, correct?
Yes.
Okay, so if we start from that premise, where do you go from there? Are you attacking the underlying order that was the basis for the obligation?
Yes, we are. And that is the first point I wanted to actually bring up. Mr. Shane and his counsel say that's not supposed to be dealt with here. The time to file an appeal from that long past, we blew the time to file an appeal. That's just not correct. We cited the Smith case, Supreme Court case, which basically says whenever there's a contempt finding, the underlying order always is reviewed. It must be reviewed is the word that the Supreme Court said. And that's the primary basis of what this appeal is all about. It's the biggest issue before this court. And I think it's the area where the trial judge just completely departed from any norms. The standard of review that this court has to apply is abuse of discretion. And as the court cases make clear, there's three ways a trial judge can abuse his discretion. Number one, by making an unreasonable ruling, by making a ruling that's grossly unsound, and by making a ruling that's just not supported by the evidence. And that's what we've got here. We've got all three of those things implicated here. We also pointed out in our brief that, you know, what happened in the trial court was just a gross denial of my client's due process rights.
But how is it, I mean, how is it a denial of due process? He basically said, put the money in escrow, in effect, pending a result of a trial, so that way everyone is protected. I mean, the receiver has obligations and needs to be able to do his job. So why isn't that kind of a reasonable step to take on the circumstances?
Well, I guess it would be a reasonable step to take if that was what was going to happen. That's ultimately not what happened and not why we're here today, because he made an order. Again, it was we seriously contested in a trial court below at the March 21st, 2019 hearing. And I really urge the court to review that transcript in detail to see what happened there. The problem is there was no evidence taken. Everybody just started spouting off and people, you know, we submitted affidavits. B and Cornell submitted affidavits ahead of the hearing. Nobody else did. Mr. Sakes came and basically said what findings he made. But, you know, Mr. Muto, counsel for B and Cornell, before, during, and after that March 21st hearing, repeatedly asked the court to hold a hearing on this because there were serious contested issues. As far as there's two issues that were dealt with, essentially. One is a $95,000 payment from Metalsa, one of their clients. And the big issue on that is what was the split date? When was that money earned? And there was conflicting, I'll call it testimony, but that really wasn't what. Conflicting arguments about when that money was earned. And Judge Barrett, the trial judge, just simply said, I'm gonna side with the receiver, because the receiver said, nope, that's all that, and it was all earned before the split date.
Mr. Stoff, let me ask you, that split date was set in August of 2018 at the time Judge Hartman appointed the receiver. Is that correct?
Actually, it wasn't, Your Honor. If you look back, and again, we pointed this out in our brief, there was definite confusion back and forth on what the split date was going to be. And Judge Hartman even said that's something we're going to have to determine. So the split date was never set by Judge Hartman. Judge Barrett never took any evidence on it, but that was one of the mistakes he made. And that is that he said Judge Hartman, and it was all based upon Shane's arguments that, hey, we set the split date of August 14th. Judge Hartman did that. And if you read the transcripts, he didn't do that. He said, that's one of the things we're going to need to determine. We're going to set August 14th as sort of a benchmark, but we're going to have to figure out who's entitled to the money that flowed into the entities before that date. After that date's not an issue, but he said before that date, that's a big unknown. And he never made that decision.
Well, but isn't that date set in the appointment of the receiver? I mean, I know the answer to my question. It is set in the appointment of the receiver, is that the split date would be August 14th, 2018. And it's my further understanding that appointment of the receiver was never appealed by your predecessor. I mean, is that
it was not.
Okay.
It was not. And what the judge clearly instructed the receiver to do is to look at things. Judge Hartman even said in his hearing, we're going to set August 14th as the date that this receiver is supposed to use, but there's not going to be any final determination made here. Let's let the receiver gather the information up to August 14th, and let's use that. But there's no final decision made, and Judge Hartman was critically clear on that. And so I guess the big question is that the March 21st hearing, the court needs to read that. The Shane brief refers to testimony that was taken. There was no testimony given at the March 21st hearing. Nobody was sworn in. Judge Baradon even censured Mr. Muto when he said, hey, we dispute this. Please consider Mr. Cornell's testimony. And Judge Baradon rebuked him on the record and said, nobody's testified here. Nobody's been sworn in. And so there was no evidence presented at the March 21st hearing at all. The Metalsa payment of $95,000 was seriously disputed. Mr. Muto, in briefs before the court and at the hearing, said it was closer to $6,000, depending upon what the split date was. And the equipment is another big issue. $261,000 is what we're supposed to come up with. $166,000 of that was equipment. And what again, I'll put evidence in quotation marks. What the evidence says is, what was submitted to the court was some of the documents dealing with the equipment was forged by Mr. Shane. Some of the equipment was contributed when the entities were formed by B and Cornell. Why should they have to pay for it twice? And the big thing is the evidence is replete. Mr. Sakes, the receiver, simply accepted Shane's estimate of the value. Everybody's talking, we need an appraiser, and Judge Baradon just accepted Shane's valuation, which was Sakes' valuation of the value of the equipment. So the 4/8/19 order was decided without any evidence. As far as the inability to pay, and I know my time is getting short, we presented evidence at the hearing that we did not have the ability to pay. And there was no evidence presented to the counter of that. The cross-examination of my clients dealt with a lot of irrelevant evidence that had to do with events that occurred long before April the 8th. And there's no evidence before the court. I get it. Judge Baradon just didn't believe my clients. But the point is there was no evidence to show presented that they had the ability to pay. The last point I'd make is we made a very reasonable offer. We put $5,000 into the court, and we made an offer, and Judge Baradon just didn't even consider it. And at that point, we were forced to file an appeal. So I would just respectfully request the court to, grant our appeal. It was a clear abuse of discretion by the trial judge and a clear denial of due process rights. Thank you, Your Honor.
May I ask a question, Judge Bergeron, before we leave? Mr. Stolf, you referenced the April 8th order setting the value for the equipment. Did your predecessor object to that order or appeal it or in any way contest that valuation at the time?
Repeatedly, both before, during that March 21st hearing and after. Now, what happened is, again, he filed a motion on the same day he was disqualified. And it's clear, he wasn't doing something in violation of the court's order because he obviously hadn't gotten that order yet, just by the clerk of court. So he actually filed a motion after the hearing on April 8th saying, Judge, please set this for an evidentiary hearing. And that was, of course, opposed by Mr. Shane. He clearly, too, wasn't aware. I guess he hadn't looked at the docket yet, but I think the next day or so, he filed an objection to that order as well. But the valuation repeatedly objected. It was discussed at the March 21st hearing. He says, we need an appraiser for this. And Judge Baradon just didn't decide to appoint an appraiser. There was even colloquy. Nobody's an appraiser. Sakes isn't an appraiser. Shane isn't an appraiser. B and Cornell aren't appraisers. But yet Judge Baradon just accepted Sakes' value, which was based on Shane's value. And that's clear in the record.
Thank you.
Thank you, Mr. Stolf. Mr. Goldwasser.
Good morning, Your Honor. May it please the court, Mr. Stolf. This case goes back before March of 2019, and I think that's an important component that this court needs to appreciate. When we look at the totality of this case, we have two separate trial court judges who had opportunities to hear the testimony of or at least the maybe unsworn testimony of both Mr. B and Mr. Cornell, much of which was actually under oath early on, regarding what they did. Judge Winkler, you pointed out that the receiver order references August 14 as the cutoff date. It does. On section 2E, it says that revenue generated under these companies after August 14 are the sole and exclusive benefit of Cornell, Ellison, and B. So putting aside the specific timing, what we have here is a situation where Mr. Cornell and Mr. B, from the onset of the case, refused to cooperate with the receiver. When we look at what occurred here, it was clear during Judge Hartman's time on the case that Mr. Cornell and Mr. B would not provide any information as to where equipment was located. They would not provide information as to where revenue was located. There was testimony before Judge Hartman that they had set up another payment account where they were receiving or providing services and charging it through Lightforce. The receiver expressed his frustration on several occasions back in November of 2018. And that was expressed both in his first monthly report, which is trial docket 28, and his subsequent report of November 19, which is trial.
Let me ask you a question about the Judge Baradon's order. He's requiring the appellant to pay a substantial amount of money in advance of trial. And normally, if you have a final order and judgment, you have the ability to stay that judgment upon posting of a bond and, so forth. But like, what protections are there to someone in appellant's position when they believe that is an illegitimate accounting, and yet they don't have the right to appeal it and get a bond at that point in time?
Well, Your Honor, going back then to April 2019, if I get my years right here, we have a situation where, after considering the subsequent receiver reports and the additional information that is part of the record, Judge Baradon did conclude that there had been funds and equipment that had been taken by the plaintiffs for their own personal use. What he was trying to do was to pull that back into control by the receiver, who was accepted by both parties and never objected to. The plan was, at that point, if Mr. B and Mr. Cornell thought that there was an inability to pay that money, it is at that point that they could have filed something with the court. They could have challenged the receiver. They could have requested a hearing. And granted, they were in somewhat of an unusual situation because, as the court may notice from the docket, Mr. Muto at the same hearing was being questioned as to his behavior in the case and the manner in which he had been handling the case on behalf of Mr. Cornell and Mr. B. In a very unusual decision, I can say I've seen that before, Judge Baradon actually issued a separate order in April where he forced Mr. Muto to withdraw his counsel due to his lack of candor to the court. There were situations where, admittedly, through Mr. Muto's statements, that funds were being diverted elsewhere. Now, Mr. Cornell and Mr. B did absolutely nothing to challenge the $265,000 at that point in time, nor did they do anything at any point in time until there was a subsequent motion for contempt, which was filed in, I believe, August. And it was at that point afterwards that the court held a contempt hearing under oath where Mr. Cornell and Mr. B were called to testify as to whether they had the ability to pay that money, because they had questioned or challenged to the court that they did not have the ability to do so. Judge Baradon had an opportunity not only to listen to their testimony at that point, there were other occasions, for instance, in February, well, actually the end of January.
Did they submit any sort of financial statements or financial records substantiating their inability to pay?
They submitted, I believe they submitted affidavits expressing that they did not have the financial ability to pay. But then on examination, it was learned of a few things. One, admittedly, they had diverted $95,000 between Metalsa and Light Force that appropriately belonged to the receivership, which needed to be returned. And it also became clear through the testimony that Mr. B had been setting up separate bank accounts that he had not disclosed, where he would literally go take money, withdraw it, and carry the cash around for a few reasons, one of which was to avoid his child support obligations. But the court looked at his behavior and concluded that he did have the funds available to pay for it. He was just diverting those and playing a game with that money. There was another situation, and granted it was after the hearing, or actually before the hearing, where Mr. B and Mr. Cornell had an attorney in Kentucky who was informed in February that money that the attorney was holding in the amount of $123,000 could have been used to cover some of the potential exposure that may exist in this case. Mr. Cornell testified, yes, we had that money, but I instructed my lawyer to distribute that money and I spent it. This is a situation where the Judge Baradon had a full opportunity. In fact, I believe he questioned Mr. B and Mr. Cornell, and he wrote in a lengthy decision that he just did not find their testimony to be credible. It's a very unusual situation, as Judge Myers and Judge Winkler probably appreciate, for the court to go so far as to conclude by clear and convincing evidence that a party deserves to be held in civil contempt. Judge Baradon did not take his responsibility lightly. He spent a lot of time and listened to a lot of evidence about what exactly was occurring. He had the benefit of the receiver report, the supplement receiver report, a second report, the statements by Mr. Muto, the statements by Mr. B, Mr. Cornell. The fact that the receiver had no ability to do anything to investigate the merits of Mr. B and Mr. Cornell's position that these numbers are wrong or that there should be different calculations occurred solely because of the conduct of Mr. B, Mr. Cornell, and frankly, Mr. Muto in blocking every opportunity that the receiver had. I think the receiver even stated in his November, or I think it was the November hearing, that while we're sitting here in this hearing, these bank accounts are having babies, because it started out with I believe Mr. B mentioning 2 bank accounts of Fifth Third, then it turned into 3 as the hearing progressed. There was a constant effort to avoid providing the resources back to the receiver who had been appointed to handle this issue. And what he concluded was, at the very least, in fact, if you look at his reports, he thought it was actually higher. But at the very least, Mr. Cornell and Mr. B had access to equipment that, in his opinion, had a value of $100,000 or $200,000, $170,000. And this was equipment that Mr. B and Mr. Cornell intended to continue to use in their ongoing endeavors after August 14. That equipment has a price, and that equipment price needed to be paid over to the receiver. The receiver was not going to do anything other than hold on to the money that was owed to the company and that properly belonged to the company until such time as the trial court or fact finder could determine who was entitled to those assets.
Let me ask you a follow-up question then, just going back to basics and following up on something Judge Bergeron said. In a situation maybe that doesn't involve a receiver, if there's a dispute over the value of company and who should have it, if we have a dissolution of a partnership or an LLC or something, you couldn't order one of the parties without the procedural protections to pay an amount of money into the court to be held without determining that that was the amount owed. And isn't, in essence, that's what's happening here? Before there's really any final determination of what's owed, the party who is alleged to owe it is being required to pay it.
Um, I- the difference is, Your Honor, is that we had a receiver who spent countless hours trying to determine what equipment existed and put together what he believed to be a reasonable value for those services. Now, whether he received those numbers from Mr. Shane or Mr. B, I think is irrelevant. We have a situation where a receiver who should have been able to handle a resolution quickly has now incurred tens of thousands of dollars, which have not been paid because money has been taken from the companies, admittedly by Mr. Cornell and Mr. B. If
But
there
I'm
was
not,
no receiver-
let me interrupt a minute, because I'm not suggesting that the receiver can't say, I recommend that ultimately the party be required to pay X because that's what I value the equipment at. But that's different than actually ordering the party to pay it right then and there.
But if that was the case, if Your Honor, if they were questioning the amount at that point in time in April of 2019, after receiving the order, then it was their obligation to object to that number, which Judge Baradon even pointed out later, there was no objection to that number.
Well, that's what I asked Mr. Stolf about that April hearing, whether there was an objection or an appeal to that valuation, and he seemed to indicate there was.
I believe Judge Baradon put it in his order, Your Honor, of November 2019, that there was no objection. He said on page 2, this is trial docket 69, no one made timely objections to the receiver's second report in accounting. And then he goes on the bottom of page 2, discussing the April 8, 2019 hearing, says this court issued an order that required plaintiffs Alan B. and Clint Cornell to 1, pay the diverted amount and the value of owned equipment, $260,000, et cetera, into the receivership, and 2, excuse me, to assume in writing various leases and financing identified by the receiver in his second report in accounting. Neither B nor Cornell objected to or appealed the order. So Judge Baradon had that information. He then goes on to say, to date, B and Cornell have paid nothing into the receivership and have not provided any written documentation regarding the leases and financing agreements. We have a situation where they just continue to completely ignore court orders or challenge those court orders at the appropriate time. If there are no further questions from the court, we stand on our brief, we stand on the record that's before the court through the trial court level, and we ask that this panel affirm the decision of Judge Baradon. Thank you.
Thank you. Mr. Stahl?
Yes, just to pick up on a couple of points. Number one, we're falling back into the same trap we had before. Judge Baradon did not listen to any evidence. The record is replete. Nobody was sworn. We had a lot of arguments going on. We got a lot of people, including B and Cornell and Mr. Sakes, talking during court hearings, but nobody was put under oath. And so Judge Baradon did not listen to any evidence, as my opposing counsel has said. Sakes reports, the receiver's reports, are not evidence. And Mr. Sakes never testified under oath about what he found in his reports and why he found what they did.
Are those reports filed? Because they're filed, they're at least a part of the record.
They are. They were absolutely filed. And I pointed out in our brief that one of the interesting things is Mr. Sakes, for reasons unbeknownst to me, didn't hire an attorney. And he had problems filing his reports. And what he typically did was he'd email his reports to the parties, and then the judge's clerk, law clerk, would file those for him with the clerk of courts. So we actually got the reports before they were filed with the court. And in fact, Mr. Muto did object to that second report on March the 15th, 2019. And that's part of the record. He filed specific objections to that report. He specifically objected to Mr. Sakes' second report in the March 21st hearing. And as I said before, after the hearing on April the 8th, he basically renewed his multiple prior requests. We need an evidentiary hearing to figure out how much is this equipment worth and how much of this Metalsa payment of $95,000 or whatever is really owed to the receivership. And Judge Baradon said, I can't consider that because it was filed after he's already been disqualified. Well, that was convenient, but again, the point is we made repeated objections.
Mr. Stahl, Mr. Stahl, let me just ask you, I have two questions. I think I'm following up on Judge Myers. And the questions relate to the April 2019 order where the court ordered your clients, well, they weren't now your clients, to pay in those funds to the receiver. And if that was a prejudgment attachment, wouldn't that have been immediately appealable? And if so, hasn't the time to appeal or object to that order passed? So that's my first question. Let me just follow up on the second question is, again, concerning April 2019. Was there any efforts, and I know you weren't involved initially, but were there any efforts on behalf of your clients between the intervening 6 to 7 months between April and November to get a clarification from the court as to when we should pay this in? Can we pay this amount in? Can we, et cetera? So it's a fairly lengthy question, but it relates back to 2019. Number one, was it a final appealable order? And number two, were there any efforts made to clarify the order?
First of all, Your Honor, I don't believe that was a final appealable order. I've characterized it as a prejudgment attachment, and that's what it is. But it wasn't a prejudgment attachment because the court never followed on any of the procedures to make it that. It effectively was a prejudgment attachment, but it wasn't. And therefore, under the case law, we were not able. That's the first thing I looked at is, can we appeal that order? And the conclusion I reached is you can't under clear case law because that orders like that are interlocutory under Supreme Court guidance, and you can't file them until a contempt citation is issued, which is exactly what we did. But again, we repeatedly objected before that and after that, and basically everything fell on deaf ears. Mr. Sakes was appointed to find money and to find what diversions of money were made, and both judges, Judge Hartman and Judge Baradon, repeatedly said we need a trial to figure this out, and we never got one. The March 21st hearing was not a trial, as Judge Baradon recognized. It was just a gross abuse of process against my clients, and again, we respectfully request the court to overturn not only the April 8th order, but also the November 12th order. Thank you, Your Honors. Happy to answer any of their questions.
Thank you, Mr. Stahl. Thank you both for your arguments. We appreciate the briefing and argument today. The case will be submitted and we'll issue a timely written decision.
Your Honors.
Thank you, Your Honors.
Take care.